Noreen, can I squeeze in here?
So let me welcome everybody officially.
My chair just broke.
Thank you for coming. I'm Peter Rosenblum, and I am I direct the Human Rights Institute here at Columbia Law School and run the Human Rights Clinic. We're here today to talk about diplomatic assurances, and for us, it's really a great occasion or opportunity. It's a subject that Columbia that we've been working on in various ways over the last 7 years, and for some of us individually, even longer, in various guises, working as the Human Rights Clinic here at Columbia. I had a little bit of engagement myself before I got here, and then collaborations that we've had along the way that have included many of the members of this panel and the organizations that they're a part of. This year and over the last year leading up to this year, we decided it was propitious to try to put what we knew about diplomatic assurances into one place and one report, and to focus on recommendations for the future. And the result of that is the report promises to keep diplomatic assurances against torture in US Terrorism Transfers, which is authored by Noreen Shah, who's sitting here to my right, but with the help over a period of years of the research of students. Each of the people on this panel have been deeply involved in the issue of diplomatic assurances over time, and what we've asked them to do today is not just to comment on the report or to comment on recommendations, but to talk about their own personal, professional involvement that led them into this field, and to deal with the issues. 10 years ago, 7 years ago, when we started here, the term diplomatic assurances was not a term of art. It wasn't clear what the scope of its application was, and where assurances were being used, and how clearly people meant the same things when they referred to assurances. Assurances might be referred to formally in legal documents that related directly to the Convention Against Torture, but they might just be commented on almost as an excuse or a justification when the government was accused of deporting or sending someone to a country where they knew that torture was practiced. And each of the people here today will talk a bit about their own entry into the field. We're going to be hearing first from Stephen Watt, who is currently a senior staff attorney with the ACLU, but in his initial engagement with the subject area was working for the Center for Constitutional Rights. And he'll talk about some of the individual cases that arose that led to his engagement, the engagement of CCR, and eventually of ACLU. Felice Gehr is the director of the Jacob Blaustein Institute for the Advancement of Human Rights. She'll be the second speaker. And she's also a member of the UN Committee Against Torture. And a number of years ago, with our collaboration, Felice engaged on an effort to try to circumscribe and understand what was happening in the realm of diplomatic assurances and what could be done in terms of improving compliance or recognizing details of what was happening in the practice. Our third speaker will be Julia Hall, who's currently with Amnesty International. Julia was previously with Human Rights Watch during the time that Human Rights Watch was the first among NGOs to take on reporting on diplomatic assurances, to understand, again, the phenomenon, what was happening, and to take positions on the uses. She'll talk about that experience as well. And then Ashley Deeks, who was with the State Department Legal Office and is currently a fellow at Columbia Law School. Our students were somewhat shocked and impressed when they found her articles on diplomatic assurances, which are the two of the reports that she did, two of the only reports that really try and capture the field broadly in terms of legal obligations and the practice of the U.S. government. And then finally, we'll hear from Noreen Shah, who First worked on the issues as a student here at the law school, has then been out for the last 3 years working with Human Rights Watch, working working in the Second Circuit, and then back here at Columbia working with us at the Human Rights Institute. Just a last word before I turn things over. We know that the use of diplomatic assurances has increased greatly. And we also know that there are detainees throughout the world in uncertain circumstances, whether they're held by foreign authorities in time of unrest. It could be in Afghanistan. It could be somewhere else in the world that we haven't yet heard about, where the authority that's capturing or that has an interest isn't necessarily the authority that has the right to detain in the long term, or that with circumstances changing, there's a need at some point to transfer those detainees, to move them somewhere else. And those pressures to do so are coming in the immigration setting, in the context of whatever we call this war on terror, and in the context of other legal procedures or less known legal procedures, less formalized procedures of the transfers of detainees. Part of our effort over these years has really been to try and understand what's going on there, and we still only have a snapshot through these different lenses. But we know that that they are being used. We perceive the use to be increasing. We perceive the practice to be now varying more among different countries as to how transparent they'll be and to what sorts of judicial review they'll subject those assurances. And that's where our report turns in the recommendations when it comes to the United States and other countries, but we'll get to that in the course of our discussion. So let me turn to Steve Watt. I've asked each speaker to talk for 10 minutes, and we'll have ample time for questions and discussion afterwards.
Thank you, Peter. I would like to begin my remarks with a couple of disclaimers. I think especially so when I'm sitting on a panel with experts who I consider experts in the field of diplomatic assurances, and I do not hold myself out in that capacity at all. I haven't had a significant experience with assurances as a practitioner. And what exposure and experience I have had was in the early years of the Bush administration, when assurances, or the word assurances, came into my lexicon for the first time when they were employed in Bush-style counterterrorism operations. My first exposure to the whole concept of diplomatic assurances came in the Maher Arar extraordinary rendition case. And even in that case, assurances didn't come into play, or the word assurances didn't come into play, or were not mentioned until after litigation was filed to seek accountability for Maher's rendition to torture in Syria. And if assurances were in play in that case, they certainly weren't diplomatic assurances in the form as described in the Human Rights Institute report. They were informal, most likely verbal assurances. My second experience of diplomatic assurances came in the rendition of two Egyptian nationals from Sweden to Egypt, Ahmed Agisa and Mohammed El-Sarhi. And Ahmed Agisa subsequently became a plaintiff in our challenge to the extraordinary rendition program, the Jepsen litigation. And unlike the Arar case, in the rendition of Ahmed Agisa and Mohammed El-Sarhi, written diplomatic assurances were obtained by the Swedish government. They were negotiated and obtained by the Swedish government from the Egyptian government that these two men would not be tortured. There was no opportunity for these men to challenge these diplomatic assurances, their removal to Egypt generally, in advance of their removal. And in the diplomatic assurances, there were certain post-removal monitoring mechanisms put in place, or the Swedish government attempted to put them in place. And in both cases, in my experience, diplomatic assurances, and if there were any in the Arar case, they didn't work to prevent torture. All three men were horribly tortured and abused when they arrived in Syria and Egypt. And this was the case even in Ahmed Agiz's case, of written assurances being in place. And what we saw was that states' rights took precedence over the human right not to be tortured. And there's 2 points that I'd like to make very briefly, and they're based on my, albeit limited, experience with diplomatic assurances. The first is that to comply with the absolute prohibition of torture, states must put in place robust judicial review procedures prior to any removal based upon assurances taking place. And that review should include review of the assurances themselves by an independent body, a judge. And the second point I'd like to make is that post-removal monitoring mechanisms, however specific and sophisticated these might be on paper, they don't actually work in practice to prevent torture. And this, I believe, is because of the nature of torture. It's carried out in secret, and because of those who carry out torture, they lie about it. So let me illustrate how I arrived at both of these points by reference to the Arar and the Agiza case. First, Arar's case. I think many of you here will be familiar with the facts of his case. So let me just talk about the assurance part.
You should just say a word about the facts, too,
Yeah,
just so people can situate. I think many of you may have heard about the case, but may not be as...
So Maher Arar was a dual citizen of Syria and Canada. He was transiting through JFK Airport on his way back to his home in Canada. He'd lived in Canada for 17 years. That was his home. He's simply going home. He ended up in the custody of US officials, immigration officials, and FBI officials, and he was interrogated for the best part of 2 weeks. He was denied effective access to counsel. He was denied effective access to consular assistance. The authorities, the US officials, went through or paid lip service to certain immigration requirements, and in litigation that was subsequently filed on Maher's behalf, they take the position, and still take the position, that this was a simple immigration removal, and that they acquired assurances from Syria that he would not be tortured. So that enabled them to send him to Syria. Some of the facts that you may not be aware of that relate to assurances in Maher's case. When he was on the tarmac, when his plane flew from New Jersey to DC, and then he was DC via Maine, Rome to Jordan. When he was on the tarmac there, he overheard conversations with his captors at that point, that Washington could not get authorization to fly Maher directly to Syria, and they were going to send him to Jordan instead. And then another part of the questionable nature of assurances, if any, that were obtained on his behalf. We filed litigation, and it wasn't until after the litigation was filed that there was talk of assurances having been obtained. When Maher was detained in Syria, there was no follow-up by the United States. They basically denied any knowledge of him. But the Syrian officials contacted their Canadian counterparts in Damascus, and Maher was visited on 7 separate occasions while he was detained by Canadian officials. Yet, despite those visits, he was still subject to torture. So that was, even if that was the post-return monitoring mechanism that was in place, Maher was being tortured. These meetings could have been improved. For example, they could have met in private. But even then, and you speak to Maher, whether he would have, in private, revealed that he was being subjected to torture until it was just way too much is debatable. So even if those meetings with the Canadian officials had been in private, it's unlikely that torture would have been prevented. In Ahmed Agiza and Mohammed El-Zahi's case, written assurances were obtained. They were negotiated at a high level by Swedish and Egyptian officials. There were post-removal monitoring mechanisms put in place. The Swedish government officials were allowed to meet with the two men. Again, they did not meet in private, but they were still tortured despite the written assurances that were in place. I think these two cases, perhaps they're, because of the national security issues that were raised by these cases, maybe they're outlier diplomatic assurances cases, but I think they serve pretty well to illustrate the 2 points that I made at the outset, that in order for diplomatic assurances to be real, there needs to be an initial pre-removal review of those assurances. And again, I think once that individual is removed to a country, it's going to be very difficult for any assurances, however specific and sophisticated they are, to actually ensure that the absolute prohibition of torture is complied with by the states. So I'll just end there, and we'd be happy to take questions once my colleagues have made their remarks. Thanks. Thank you.
Felice?
Well, thank you. Well, thank you very much. I first encountered this issue as a routine matter at the Committee Against Torture, because the Committee Against Torture has an optional procedure which allows for individual complaints. And the way it's worked out, the immigration lawyers in Canada, Australia, Sweden, a few other countries, Netherlands, Switzerland, have discovered Article 3 of the Torture Convention. Article 3 of the Torture Convention differed from the Civil Political Covenant and from previous instruments in making, the Torture Convention as a whole differed in making the ban on torture absolute, and that's affirmed in Article 2, which says no reasons, no emergencies or exceptional reasons are able to validate torture under any circumstances. Article 3 adds the dimension, which didn't exist elsewhere, which was that explicitly saying that if a person faces a substantial risk of torture, he or she should not be returned to the country. Now, this plugged the loophole in the Refugee Convention. The Refugee Convention, if you are a security threat to the state or more or less any other reason like that, a political reason, the state can refuse you refugee status and is not supposed to refile you, but lots of states are ready to do that. When a person fails to get refugee status in one of these countries I've just described, countries with generally a good record on immigration, they have turned to the Torture Committee under Article 22, and they've asked us to evaluate Article 3 to prohibit a person being returned. And I would say that 90% of the cases, maybe 95% of the cases, individual complaints that have come to the Torture Committee have been under Article 3. And the committee looks at these issues and addresses probabilities. it's the only element of the convention that doesn't deal with a fact. It's not fact-based, it's probability-based. And you don't find that in most of your human rights instruments. So we had a case by a woman in Sweden who, whose husband.
Ahmed Akisa's.
Yes, of course. I'm trying to be a little cute about it. The Attia case. We had this case from this woman in Sweden who appealed to us for interim measures and for not returning her to Egypt. And our committee was concerned because she did this from hiding. And we feel if you're going to take advantage of the protections of the convention, you have to trust in the country that you're appealing to implement it. So there she was in Sweden, a generally good country, refusing to come forward. She was in hiding. And we said we wouldn't provide interim measures unless she came forward. She did. We reviewed the case. Long story short, we made a determination that she wasn't at risk, that her husband was at risk, but that she wasn't at risk if returned. We then began to hear, it was the time when one heard about what was actually going on in the world. And we began to hear about the fact that that there were incidents and more incidents where people were being taken for questioning, returned, kidnapped, exchanged. Something was going on, and it was in the media. You were all too young. Well, not all of you, but the students among you were probably too young to have followed this. And as a result of this, what was obvious was that there was a contradiction between the Torture Convention, which has an absolute prohibition on torture, and what was going on at the Security Council, where Resolution 1373 said explicitly after 9/11 that states had to deny safe haven to terrorists. And there was a question here about how do you not return somebody to face charges of terrorism? And most of the cases we get would either be charges of terrorism, or we get murderers, drug dealers, and others who are viewed as undesirable in these countries. But rather few cases that aren't that way. And so the question was, well, do you return terrorists or not? What kind of mechanisms exist? How do you protect? Everybody has a right not to be tortured, so you want to protect people from that return. At the same time, you have a binding resolution of the Security Council that says no safe haven for terrorists. How do you put these two concepts together? And it soon became clear that this mechanism called diplomatic assurances, which Peter and his clinic were working on, was something that was being resorted to by the U.S. government in particular, but that it had a history, and that the history was more than just in the context of returning people facing charges of terrorism. In fact, it had been widely used for a death penalty, people facing the death penalty not being sent to the U.S., for example, and other such cases. And states would, at the level of the foreign ministry, or in our country, the Department of State, engage with each other and write a little diplomatic note, come up with some agreement. It was, well, we didn't know what was in those agreements. We knew there were agreements, and we knew that the states insisted that they were just fine, thank you very much, but we didn't know what was in them. And so we spent a bit of time with Julia and Peter and experts from various committees and rapporteurs and so forth, talking about the question of whether there were effective measures to render people back to justice and whether diplomatic assurances were a safeguard or a loophole. And that was always the question that came before the members of the committee formally, but it came before us as advocates as well. In the right circumstances, death penalty, the assurances were a safeguard. In the wrong circumstances, possibly in a situation where a country was only too eager to get somebody behind the scenes in a closed place and utilize torture, it was a loophole to avoid the absolute prohibition that's in Article 3 and in the Torture Convention. And so we struggled, as Noreen has outlined in her report. There was an early view that assurances were a safeguard. And even though nobody had seen the assurances, Nigel Rod Lee said that they could be a safeguard. Theo van Boven said they could be a safeguard.
These are both Nigel Rod Lee, who's really one of the experts on the law of torture, was at the time the UN rapporteur on torture leading up to and before 9/11, and then Theo van Boven, a Dutch jurist, took over from him.
Context. It was not until really the Swedish NGOs, Julia Hall and Human Rights Watch, focused in on the Agiza case and what had happened, because it was such a cause célèbre in Sweden, that this issue really came to be focused on, are diplomatic assurances a loophole? And if they aren't a loophole, what would make them something that was reliable? We spent some time informally talking about the need for them to be transparent, the need for them to be something that could be challenged, something that could be monitored on the return of the individual, effectively, whatever effective monitoring is, and where the individual would have an opportunity to legally enforce the assurances, or to at least challenge them in some kind of administrative or legal body that was independent, fair, and would be protective. The Committee Against Torture was besieged with information on this particular case, and with the very scant information that existed on, what were there, maybe 8 or 9 cases that we knew of anywhere where a person had been subjected to diplomatic assurances. And we had maybe 2 or 3 examples of what diplomatic assurances looked like. Couldn't get anybody in the government to tell us about it, and we did try. I remember, and Peter and I were talking before this meeting about how we tried to get somebody from the government to come to this consultation that we had, and of experts, an NGO event. And we did. We finally got a young woman from the Department of Homeland Security, which had just been created about a year before, who came. She said, "I'm the person who does diplomatic assurances," and she assured us that there had been less than a dozen diplomatic assurances ever actually negotiated, and that this was really very rare, exceptional, and was very carefully carried out. Again, no documentation, no examples, and no case follow-up. But she was willing to come and talk with us about it. When the Committee Against Torture then had the Agiza case to adjudicate, it got into the question of what really had happened. And we discovered that the Swedes had they'd exchanged notes with an ambassadorial official, if I remember correctly, not a high-ranking minister or deputy minister or somebody in charge of the security facilities or anything, but rather with another diplomat, because the diplomatic word of one country is fine for another country, right? What then happened was we learned that they had exchanged notes, and Agiza had been, I think the only word to describe it is snatched, and sent back to Egypt. All those details are readily available. But the Swedes didn't do anything after that. Did they do anything to see if the government had treated him well or not? They waited 5 or 6 weeks before they visited to see his conditions. Now, if you work on torture issues, you know that the first 24 hours, first 48 hours are the time where people are broken, where they're kept incommunicado, and which is the most dangerous time when a person is at risk of torture. The idea of leaving somebody that you said you were going to have post-return monitoring for 5 or 6 weeks is like an eternity. And it suggests a lack of seriousness. Now, why was there a lack of seriousness? Because diplomats are not trained to examine psychologically or physically torture victims. They are trained to be diplomatic and to write notes, to work with words, but not otherwise. Now, I'll fast forward and say that the Committee Against Torture found the government of Sweden in violation of the convention in terms of this return. The committee asked the Swedes to take reparative steps as soon as possible. And to this day, the committee's been following that case. It's about 5 years down that's been going on. And we've learned even more about what the government did and didn't do and how it was and wasn't trained. In fact, they even told us they did things that they didn't do. And it makes the idea that the word of a government to another government is an adequate assurance something that's the subject of ridicule, and certainly was during that time period. Now, since that time, what has the committee done? I have about a minute left. The committee has, in 15 cases, 15 countries' cases, has addressed the issue of diplomatic assurance and asked those countries, all of them from Europe except for Australia, Philippines, and arguably part of Russia, has asked them, do you accept diplomatic assurances? How many cases? What are the examples? What are your minimum requirements for a diplomatic assurance? What kind of post-return monitoring do you do? And is there any legal enforceability? We asked that about 10 of the countries. Some of those countries, Russia, Azerbaijan, Kazakhstan, there are issues of returns all the time and involving other countries that are systematic, that are known to be involved in systematic torture, or countries like China, where the return, or Uzbekistan, where a return of somebody who's already wanted by the police to the police is going to create a problem. What happened after about, and by the way, these countries don't respond. They don't tell us to this day what they do. So this absence of information continues. The cases of Netherlands, Algeria, Sweden, and Austria, however, the committee praised each of them. It praised them for affirming to us, sounds like a diplomatic assurance to me, for affirming that they do not accept diplomatic assurances. So now we're praising governments for not accepting diplomatic assurances. Noreen's report will tell you the way in which the thinking on this has changed in that regard. We continue to have a problem with figuring out whether there can be a safeguard in this regard. If all these elements were addressed, whether there could still be assurances that were safeguards, and whether or not there are loopholes. But certainly the experience of the last decade indicates that diplomatic assurances have been utilized in the context of torture and of terrorism as a loophole. Thank you.
Thank you very much. Our next speaker will be Julia Hall.
Well, I want to thank Peter, who I haven't seen in a very long time, so it's lovely to see you, for inviting me to participate. And I want to congratulate Noreen and Peter on the report, because the report is indeed really quite comprehensive. And from my perspective, a far cry from the old days, when you could Google diplomatic assurances and absolutely nothing would come up. And I mean nothing. And so as I see the literature build, it's very gratifying as I see opinions like Felice's that, are expressing healthy and I think justified skepticism. It's very gratifying to me. Peter asked us specifically to talk about how we came to the issue of diplomatic assurances. And so the formal presentation that I had written telling you why I think they don't work and shouldn't be used is in the dustbin. And so I'd just like to maybe tell you the story of how we came to it, why we thought it was so important, and where we're at right now. The first time I actually saw a reference to diplomatic assurances was in a 2002 report. It was a draft of an OSCE report on the current state of play with respect to human rights protections in the context of counterterrorism operations. And it was the Sweden entry. And the entry was only 4 sentences long. But one of those sentences said, the Swedish government secured diplomatic assurances against torture, promising that Agiza and Al-Zari would not be tortured and would have fair trials on return. And so I called the editor of the report, who was an old friend of mine, and I said, this must be a typo, because diplomatic assurances against torture, there's no such thing. And if there is, we are in really big trouble. And so we were able to verify, actually, that the Swedish government had, in fact, gotten diplomatic assurances from the Egyptian government. And so that really was the first time that I think the human rights community in Amnesty put out the first urgent action on Agiza and Al-Zari and referenced the diplomatic assurances. The OSCE included it in that first report, and then I think Human Rights Watch, very, very much to Human Rights Watch's credit, and I see my colleague, my former colleague Joanne Mariner here as well, Human Rights Watch really prioritized this issue as an issue of real importance in terms of the prohibition against torture. Little did I know at that time that my professional life for the next 8 years would be taken up with researching, analyzing, creating, amicus briefs, expert affidavits in courts all over the world with respect to this issue. Peter likes to call this a quirky issue, and it is a quirky issue. It seems very small and it seems very narrow, but it is immensely important. When we decided to start to look at this issue, we could find no references to it anywhere. We thought, okay, we'll write a report and bring this to a broader public. And we couldn't find nothing, and I remember calling all of the colleagues and saying, have you ever heard of it? Do you know any cases of it? Amnesty International sections were engaged right from the beginning. And we must have called, I don't know, dozens of people and said, do you have any idea? Have you ever heard them being used? And at first people really scratched their heads, but very slowly we started to uncover cases that had actually occurred prior to 2001, because in the common discourse, people believed that this was really a function of George Bush's war on terror, but we came to learn that in the UK, assurances had been used the government had tried to use them as early as 1992 in the Shahal case. They tried to use them again in 1999 to deport 4 Egyptians. And in that case, quite an interesting case, and I think Noreen has this in her report as well. Tony Blair had set out a whole list of assurances that he wanted the Egyptians to give. And the Foreign and Commonwealth Office and the Home Office fought back. They really fought against the return of these Egyptians, to the extent that at one point Blair wrote on a memo, just get them back, right? So I think it really, in some ways, crystallizes in that moment the notion that diplomatic assurances, for many governments, provide an easy tool to rid themselves of persons that they don't want to prosecute, but they don't want to keep on their own territory. What we uncovered in addition were cases where there were diplomatic assurances. They were quite prominent in the case, but people didn't recognize it as an actual phenomenon. So, for example, Ahmed Zakayev, who was then a Chechen leader in exile, was subject to an extradition proceeding in the UK in 2003. 2004, and the diplomatic assurances were a very big piece of his case. A Russian official actually came to the UK to testify that he personally would see to it that if Ahmed Zakayev was returned, that he would be safe in Russian custody. And the magistrate didn't buy it. I mean, essentially, Zakayev was not extradited, and in the decision you will see the judge saying, how can we possibly trust that with the vastness of the Russian prison estate and the types of violations that occur on a daily basis, especially with respect to Chechens, that this person would ever be safe. So there, again, you had a very high-level official who had direct control over the custodial spaces within which this person would have been placed, who promised a judge, and also promised that there would be room for post-return monitoring. And the judge, I think, very astutely said, this just simply is not reliable. Once he leaves British territory, we have no control. We don't know whether we don't know whether you'll keep the promise. So there was information out there, but I'll tell you how it was so difficult. We actually had to have Peter's students, we called them last minute and said, we have this report that we need to put out. We just don't have enough information. Can you guys do something on the US? We'll get our counterparts in Sweden and we'll see if we can piece together an initial report. And so in 2004, I think it was the first NGO report that on this issue. But you'll note that first Human Rights Watch report, which was titled Empty Promises, was an extremely slim volume. Right? And so we were a little bit cagey. We thought, are we making too much of this? We're just not really sure. But the events between the publication of that report in April 2004 and the events right up till December 2005 gave us some real confidence that we had scored, if you will, in identifying an issue that should be brought to a broader audience. So what happened between the publication in April 2004 and December 2005? 4 things happened. First, in the United Kingdom, the UK government's attempts to indefinitely detain without charge or trial terrorism suspects was ruled unlawful. And in September of 2004, the government, in a memo, said they were basically being questioned by various other arms of government and parliamentarians. What are you going to do now, essentially? And they said, we are going to implement control orders, and we're going to examine the possibility of sending people back to places like Jordan, like Egypt at that time, Lebanon and other places, based on diplomatic assurances. So all of a sudden you had an issue going from this individual case level, where you saw it here and you saw it there, rising to the level of policy, of government policy. You also had in the United States, we had discovered through Peter's students something that I think really went under the radar for a very long time, and that was the regulations to the Foreign Affairs Reform and Restructuring Act. And in 1998, those regulations were issued, and they included provision for diplomatic assurances in immigration deportation cases.
Can I just say that it's pathetic to refer to the discovery of public regulations as such a discovery? So as much as I like the compliment to the students, it seems tragic that that was actually a discovery.
Well, we're all part of the tragedy then, because none of us knew. So we understood that, and because of the case of Maher Arar, right? Maher came back to the States in 2003, but really the case gained notoriety. He came back in 2003, gave a very detailed statement to Amnesty International Canada. But it really wasn't until 2004, 2005 that the case gained the prominence that it really deserved and gave rise to various forms of legislation in the United States. So, for example, I think it was fall of 2005, the Markey Bill was tabled, which really was, I think, a direct response to Maher's case. So we saw some things happening. So is that the third thing? I said there were four things. In any event, there are four things. That was the second. The third thing was we saw in returns from Guantanamo Bay, in specific, detainees who were from countries that had very poor records of torture. We had understood that the U.S. government not only was going to seek assurances in the context of immigration deportation proceedings, but also with respect to the returns of Guantanamo Bay detainees. And in fact, the Guantanamo bar was coming to us and saying, how can we talk about these assurances? Are they reliable, et cetera? And the fourth thing that happened, and this happened in December of 2005, was on the eve of a trip to Europe, Condoleezza Rice, former Secretary of State, gave a speech, and the speech was in direct response to concerns about the U.S.'s rendition program. And she acknowledged the program. She acknowledged that there were concerns about torture, but she said in any case where there is a rendition, we seek and secure diplomatic assurances that that person will not be tortured or ill-treated on return. So we had a flurry of activity in those 2 years. In the meantime, Human Rights Watch did produce a second report in April of 2005. All right, so that report preceded Condi Rice's statements, but that report was now 100 pages long. All right, in 1 year, we had gotten so much information about the use of diplomatic assurances and about the intended use of them by governments. In other words, governments toying with the idea, like the UK. And one interesting story to recount is, at this point, we were very conflicted at Human Rights Watch because we thought, should we be drawing so much attention to this? Are we giving governments an idea of how to do them in a way that might be human rights friendly? Should we even be drawing this much attention? And I remember going into a Home Office meeting in late 2005 with very high-level Home Office staffers, and they all walked in with that 2005 report. It was called Still at Risk. And the report in some instances had, dozens of sticky papers sticking out of it. In one instance, it was dog-eared. In other words, they read it. They really read it. Now, as a human rights lawyer, human rights activist, you want policymakers, you want government lawyers to read your reports. But we knew, almost in that moment, that what we really were engaged in was a struggle as to whether we could convince governments that it was in fact a loophole and they shouldn't be doing it. Or what we were doing with our documents was saying, here are our problems with diplomatic assurances. Here's where we see this as problematic, and giving governments the idea that if we can fix it, we can actually conduct these transfers in a way that's human rights friendly, and we can stave off criticism from the human rights movement. Well, I'm happy enough to say that that didn't happen. There is no government that has employed diplomatic assurances against torture who hasn't earned our criticism. On the other hand, you will note the proliferation across Europe of the use of this tool and how it has actually seeped into other types of transfers that we really didn't anticipate. And in this instance, I would note in specific detainee transfers in Afghanistan. So what we've seen is a real attempt on the part of the human rights community in particular, but also academics and the legal community, to deeply analyze the implications of the tool. So we analyze, as Stephen has said, how the dynamics of torture themselves militate against this tool actually being a safeguard. We've analyzed the limits of diplomacy with respect to ever prioritizing human rights considerations over other national interests. And if there's one thing that links Stephen's presentation with Felice's, is the fact that the Swedish government lied. They didn't reveal critical information about the men's fear of torture and the fact that they had in fact been ill-treated in detention. They never actually revealed that to the committee until quite late in the game. We have a case in Spain now, and then I know I only have 1 minute, but to really further emphasize the notion of how governments will, in fact, lie in order to meet other national interests that even, they may be legitimate national interests. But if we're going to talk about whether diplomatic assurances can work, we have to talk about whether governments are honest in terms of their communications with other governments. The Spanish government, in a recent case of a Chechen who was subject to extradition, the Spanish government lied to its own courts twice by saying that they had gotten intergovernmental bodies to actually agree to monitor this Chechen in Russia once he was returned. Both organizations were completely unaware of the case. It was an intervention by NGOs coming to them and saying, did you actually agree to go and monitor this guy? No, we never agreed to it. We never even heard of the case. So the inherent limits of diplomacy also militate against diplomatic assurances being an effective safeguard. And one final point, and then I will stop. It's not only the practicalities about diplomatic assurances. Can you create a regime where it will work with respect to this one individual guy? It is the fact that for decades, the international community has painstakingly tried to come to consensus about the absolute ban on torture. And within that consensus, it has been agreed that there are a constellation of things that absolutely need to happen for torture to be prevented and eradicated across the globe. There needs to be judicial reform, legislative measures, training, forensic, there needs to be forensic issues that have to be addressed, a whole complex of things that really need to occur. And when you take one person and you say, we're going to protect this one person, of course, we don't believe that can happen, but let's just say theoretically it could. And you carve out an alleged island of legality and a sea of illegality where torture is occurring in a general way every single day. You really seriously undermine the global project to eradicate torture worldwide. Okay,
Thank you.
Very much.
Just before Ashley begins I just wanted to mention that Stephen may have to leave us early, so I wanted to make it.
I'll talk fast.
No, it's also that that if he walks out, people will understand that he hasn't suddenly.
I'll talk fast and time it so that when I finish, he walks out.
Okay, excellent.
Just a few caveats. I was with the U.S. government for a number of years, working on issues related to law enforcement as well as political military affairs. And obviously, I'm speaking here today in my personal capacity and not as a government or former government person. Like the others who've spoken, I'd like to congratulate the Human Rights Institute for a very comprehensive report, and I appreciate its largely pragmatic approach to what is obviously a very difficult issue that reasonable people can and often do differ on. Let me start by saying a little bit about why I got involved in this issue, and particularly why I wrote a couple of pieces, both a policy piece and a more legally focused piece on the issue in 2008. I had been with the U.S. government and, like I said, had worked in an office that dealt with extradition issues, so I was familiar with the idea of diplomatic assurances. And I subsequently worked on political military issues related to detention and so on, so I saw assurances popping up in a different context. So I took a fellowship year and wanted to find an issue in the face of the 2008 election, which was pending. And it struck me that there were a number of war on terror policies that the Bush administration had pursued that were wildly controversial and were most likely going to disappear, whether President Obama or the nominee Obama won or nominee McCain won, including issues related to interrogation and torture, where both the candidates had been pretty clear about their positions on those issues. So I wanted to focus on an issue that I thought both the US government and other governments were going to continue to have to wrestle with in the aftermath of those elections, and that they weren't going to be able to stop confronting, at least in the near term, and quite possibly in the longer term as well. It also struck me that humane treatment assurances are an issue in closing Guantanamo, and if you thought that President Obama was going to win the election, you might have thought that he was going to be interested and turn a spotlight on closing Guantanamo, but part of that was creating space to transfer individuals back to particular countries, and so that struck me that there was probably going to be a continued turning to diplomatic assurances to see if that could help facilitate concerns in that area. And diplomatic assurances were coming under fire in various circumstances. As Julia just noted, human rights groups were very much starting to focus on some of their shortcomings. And there were a number of court cases, both related to extraditions and deportations, which were other areas where they were being used. And there were varying results coming out of these processes, and that struck me as sort of interesting and maybe something worth focusing on. And it was also an issue in which our allies were struggling. As others have referred to, you had countries such as Sweden, Turkey, Switzerland, Austria, the Germans, the Slovaks, the Dutch, the Canadians, the US, Denmark, and Norway all dealing with this issue. And for many of the issues that the US government was working on under the Bush administration, it often was taking a position that was kind of out on an island compared to where the rest of its allies were. So that was another reason I thought there could be some sort of cross-pollination of ideas about how to improve the process based on the practice of other governments. And I do think that assurances can be a valuable tool, but I also thought that the US government was incurring reputational costs that by adhering to the status quo process that it was using. And so I thought that there was potentially some room to suggest changes that might diminish that reputational cost. And finally, it struck me that the world was changing, that Congress, as others have noted, was starting to pay attention to the issue. There was draft legislation that would have prohibited their use entirely. And courts were, some of them were quite concerned about the way in which the government was using assurances and its unwillingness to share those assurances with courts. So again, it struck me that if the executive branch didn't seize the reins and change some of its policies, some of the other branches of government might force it to do that. So that was sort of how I got into the issue, and I'll circle back at the end. I'm less confident about that last statement now. The world hasn't necessarily changed in the direction that I might have anticipated just before the 2008 election. So I'm not hugely optimistic about where this is headed. So let me just make a couple of points. One reason that this issue is hard and it's persistent is because the alternatives are often legally, morally, or politically unpalatable. So while it is perfectly appropriate to talk about the problems of assurances, I think it's useful to keep in mind, especially for people who are thinking about doing work in government, that there are often kind of real-world problems on the other side that lead governments to turn to these assurances, and those include a concern about an alternative of indefinite detention that clearly has its own legal, political, and moral problems as well. The release of dangerous people onto your territory comes with at least political problems, if not some other problems. And sometimes criminal prosecution, which often would be the best option in any of these cases, isn't available in a particular situation. So that alternative, while it's nice to have and can solve some of these problems, is not always at hand. So I just think it's important to keep the alternatives and the pressures in mind when people are talking about this issue. And so just to give you an example based on something in the report, there's a discussion about transfers by members of the International Security Assistance Force in Afghanistan to the Afghan government. And obviously the troops in ISAF don't want to send detainees into facilities where they're going to suffer torture. But then you run into questions about, well, what happens if, for example, the Afghan government waves its hand and says, we want all of you guys out of the country, and or the Security Council resolution that's supporting the presence of those troops isn't renewed. So then you have dozens, hundreds of detainees on your hands, and a real problem about what your alternatives are to turning them over to the host government. We're not at that phase yet, and I don't know how governments will handle that when they do, but that is one potential issue that they may face. And an alternative that the report suggests, or maybe the Canadian people in Canada have suggested, is for Canada to develop its own facility. But at this point, the troops have basically set up a rule whereby they'll turn Afghan detainees over to the Afghans within 96 hours. So they would have to kind of revisit existing policies, and maybe that's the right approach. The best fix is very long-term, and it's very hard to achieve, and that is to help the Afghan government set up facilities that are, 100%, everybody is extremely well trained, they're not corrupt, they are sort of up to Western standards, and that is not a fix that's going to happen in the short term. But of course, that's the ultimate fix for a lot of these concerns. So anyway, but the point one is basically that there are often no satisfying options in this area. Point number two, there's a theme in the report, I'd say, that goes to transparency. I firmly agree that the U.S. government should be engaging more publicly on these issues. It has been not very forthcoming in its approach. John Bellinger, I guess a couple of years ago, did testify, but I think there's a lot more that the government can say in defense of its case, and I think it should, I think both sides of the issue would benefit from the government being more forthcoming. It obviously can't say everything. There are kind of classification issues on some of this, but it could explain the dilemmas. It could explain more details about monitoring and so on. I just note as some of you may know, when President Obama came into office, he issued 3 executive orders on his first or second day. One of them had to do with reviewing the process of transfers. And so the executive branch as a whole basically got together and in a task force looked at this very issue. And it has only basically issued a press release explaining a couple of the recommendations that came out of that task force. And I think that it would be useful if the government felt like it could be a little more forthcoming on some of that. It was also a good opportunity for all of the relevant agencies to get together in one room and have useful discussions. And it did take the task force very seriously, but just having a government official say, we took this issue very seriously, isn't very satisfying to people in this stage of where we are. Point 3, and this is also suggested in the report throughout, the hardest argument for the U.S. government to sustain at this point, I think, is this longstanding view that it's had that assurances need to be kept secret. Assurance practice started in the extradition context. I think there were good reasons that it was treated as diplomatic exchanges between governments, which very often, as a rule, aren't made public. But that ship has sailed in many ways, I think. The practice of the United Kingdom has been to negotiate very detailed assurances, make them public, share them with the courts, and the U.S. arguments about why that's not appropriate for the U.S., I think, are less persuasive these days. On the other hand, I would say I don't think that things like the WikiLeaks releases will necessarily cause the government to say, well, confidentiality is just less important to diplomacy anymore. I think it may change the modalities of how diplomacy happens, but I don't know that WikiLeaks per se is going to sort of crack all of this open. Point 4, just briefly, there have been a lot of discussion about judicial review, and I think that's often something that people like to raise and turn to as a significant fix for some of the problems that are attached to assurances. My suspicion, at least as a practical matter, is that it is going to be not anytime soon where the executive branch embraces that affirmatively as an option. I think that's particularly true when you're talking about judicial review of transfers that are occurring basically on the battlefield. So people held by the multinational forces Iraq when they were transferred to the Iraqi government, and people held in Afghanistan by ISAF and OEF forces transferred to the Afghan government. I think the mechanisms that would be required to establish judicial review in those contexts is very complicated, and it would be very hard for me to imagine that is gonna happen, at least in the medium term. I'd also say that full judicial review does come with costs. I think the UK has found that process quite costly, and it publicly talks about how desperately concerned it is about the national security implications of some of the court's decisions in this area, where it is, its latest report suggests that it's planning to rely more on diplomatic assurances in the context of deportations because it feels as if it is facing a number of very serious security threats within its territory by non-nationals, and it is less able to rely on other alternatives such as control orders. I do think that there is room for particular, some kind of judicial review. I guess I would focus more on a sort of procedural type review, not unlike how courts review executive determinations of foreign terrorist organizations. It's almost an administrative procedures type review. So you get some of the benefits of having a neutral adjudicator looking at the process, but I don't know that courts are specifically, substantively in a better place to review things like the nature of the person who gave the assurance, some of the classified intelligence that the US government may have on the issues. So let me just make my final point looking forward. As I mentioned in the beginning, I'm not hugely optimistic that there's going to be a lot of change within the US government's policies in the medium term. I had suggested a number of proposals in some of the writings I'd done. The task force took a few of them on board. It did not take all of them on board by any stretch. And I'd say the political climate is less hospitable right now. The Christmas Day bomber, growing domestic terrorism threats. There's not a lot of pressure from Congress right now to have the United States go sort of, it would be perceived, I think, as going lighter on terrorism. Whether that's actually the right way to think about it is definitely a question that I think my fellow panelists would not tee it up that way. But I think that is how it might be captured in the political arena. I'd also note that there are a couple of court cases that have come down in favor of the US government in this area, which I think also takes the pressure off the US government to actively be pursuing a change in policy. And these are the Kiemba II and the Munaf cases. And I also think that the need for diplomatic assurances is not going to disappear in the short term. You have Guantanamo detainees, where I think the executive will continue to look to diplomatic assurances as a way to try to transfer people out. You have expectations on the battlefield now that it does matter that the detainees not face mistreatment. In the Geneva Conventions, that actually wasn't an approach. You were expected to be able to send your prisoners of war back to their home countries whether or not they faced torture. I think state practice has evolved since then. But as long as we have non-state actors from countries with bad human rights record taking up arms in these conflicts, I think the ingredients remain present for a continued reliance on assurances.
Thank you very much. Our last speaker, Noreen Shah.
Thanks. I just want to say thanks to the panelists. This has really been amazing because we have here some of the lawyers and practitioners who've been researching diplomatic assurances the most of anyone in the entire world. So it's been a privilege to have these experts here. And I also wanted to take this opportunity to thank all the students who worked on this report and to thank Peter for supervising and editing the report. The clinic students last year especially had a hard time with me because it was a lot of hours, and I see some of them here, so I just wanted to say thank you very much for doing that. By now I think you've heard more than an hour about diplomatic assurances, which is a lot for a subject that really doesn't get much news play. And You could have titled this event Diplomatic Assurances, All You Ever Needed to Know or Wanted to Know About Diplomatic Assurances. And I wouldn't really need to speak because everyone's already said so much. So with that in mind, I want to take a step back and be somewhat inflammatory by talking about an issue that at first blush seems very remote from the issue of diplomatic assurances, and that's the increased political focus on the supposed threat of homegrown terrorists in our midst. Yesterday, as you all, maybe some of you know, Secretary of Homeland Security Janet Napolitano testified before Congress that we are facing possibly the most heightened state of a terrorist threat since 9/11. She locates that threat rather than merely from outside the United States as inside the United States. The threat has evolved, she said, to include plots by American residents, plots by American citizens who are already here and who could strike, who could carry out these acts of violence with little or no warning. The chairman of the committee hearing where she spoke was Peter King, who is a congressional representative from New York, and he plans to have a series of hearings next month to examine the threat of Islamic radicalization. So what's the connection between the Peter King hearings that we'll be seeing very soon and diplomatic assurances? Well, as somebody who's written more than 100 pages in a somewhat pragmatic approach to the issue of diplomatic assurances, I think I can afford to talk about the normative discomfort that many of us have with the idea of sending people to places where they might be tortured based on the promise of people who routinely torture. The link between these two things is that we're doing something that we don't really want to do, but we're doing it because we must. We don't really want to have hearings about American Muslims. We wish they weren't such threats to us, but we must. Because as Peter King has said, we face a unique and diabolical threat. And of course, national security only ratchets in one direction, and since I've been working on this issue since 2005 when I was a student here, it's only ratcheted in one direction, unfortunately, even with President Obama. So, with this looming threat, we're forced to do things we don't want to do. And to quote Donald Rumsfeld, who was on Fox News on Tuesday, 2 years after Obama, we're doing things not because anyone wants us to be doing them, but because they're the best solutions. I think diplomatic assurances, hearings about Muslims, indefinite detention at Guantanamo are all best solutions in the current political environment. I won't belabor this link too much, except to say that there's something wrong with something that was first justified as necessary because of an extraordinary set of circumstances, continuing because we are now in a ceaseless set of extraordinary circumstances. But that's an inflammatory link that I've just made between the King hearings, which a lot of people would disagree with for various reasons, and diplomatic assurances. Most of the government officials I've talked to about diplomatic assurances, most of the things that I've read about diplomatic assurances, evince very good intentions. It's not just that it's the best solution that we have, it's that we really want this to work. So the idea of sending a person purposefully to be tortured, whether it be Maher Arar, or sending someone and being indifferent to their torture for 5 weeks with Agiza and Alzeri from Sweden is really out of vogue. Even Donald Rumsfeld's merely been confined to Fox News rather than anywhere else, and torture is once again the catastrophic moral horror that it ought to have been. And the narrative even of what diplomatic assurances meant is now changing. As Julia was saying, when in 2004, 2005, no one knew what diplomatic assurances were, and torture was something that was kind of looming on the horizon. In Bob Woodward's most recent book, Obama's Wars, he says that not even back then, really, was anybody ever talking seriously about sending people to places to be tortured on purpose. And he recounts a conversation between Michael Hayden, the CIA director under the Bush administration from 2006 onward, and an unnamed senior officer. Leon Panetta had just testified in his nomination hearing that the CIA had sent people to foreign countries for interrogation using techniques that violate our own standards. So in Woodward's rendering, which is always very suspenseful and exciting, Hayden breathlessly, he sees Leon Panetta on TV and he breathlessly picks up the phone and calls the senior officer and he says, "You watching TV? Okay, no bullshit. Have you ever?" And then the senior officer replies, "No." Hayden, "You've always sought assurances." The senior officer, "Absolutely." Hayden, "And beyond the assurances, you used all the tools available to an espionage agency to ensure that they're living up." Senior officer, "All the time." Hayden, "I'm not talking about on your watch, I'm talking about forever." Senior officer, "Forever." We've always done our best. We've had the best intentions. Promises to Keep, this really lengthy report, starts from the premise that that's true, that the US government has had the best of intentions, or at least it does now. But it argues that we aren't doing our best, because we at least know that other governments have done more. The US stands alone among its allies, as others have recounted here, in resisting judicial review of assurances in any form. Dozens of countries, European countries, have submitted to scrutiny before the European Court of Human Rights in deportation cases involving assurances. But our Justice Department in the Guantanamo cases has resisted that kind of judicial review. And you could read about that in this rather lengthy report. The US is also claiming it's doing its best on monitoring. And here I'd want to say that we've talked about Giza and Al-Zaria and Arar, and these are all cases that happened a few years ago, but these are issues right now with the Guantanamo detainees. And to illustrate that, I think if you think about the people who are still at Guantanamo who are facing either prolonged detention there, more detention there, or being sent home, it's astounding that some of them actually would rather stay at Guantanamo than be sent back. One of those individuals, two of those individuals rather, were Tajik detainees who were sent back in 2007 to Tajikistan. And unreleased WikiLeaks cable is proof of the fear, maybe not proof, but it certainly evidences a real problem. Now, these two men were sent back in 2007, and after a really breakneck speed trial, they were convicted and sentenced to 17 years in prison. And at their trial, both men cried out that they had been tortured. Now, the US sent these men back based on presumably diplomatic assurances, because by that time we had been getting diplomatic assurances for everyone from Guantanamo. We had sent them back despite our State Department report that year saying that living conditions in Tajik prisons were harsh and life-threatening, that beatings and mistreatment were common, that security officials used systematic beatings, sexual abuse, and electric shocks to extort confessions. So despite that record on torture, we sent these two Guantanamo detainees who had already been indefinitely detained for years, we sent them back. And then we checked up on them, and that's where the WikiLeaks cable comes in. It's a report of the visit by US Embassy officials to see what's happened to these guys. And the report is from 2009. It's a report that is focused on the treatment of a man named Sharapov, one of the detainees. In the report, it's described that for 3 months, the US officials weren't even allowed access to the person, to Sharapov. But they dismissed this delay as lengthy and confusing for all concerned. Then when they finally get access to him, they're having to interrogate him in the presence of his captors. They do so, and they ask him to confirm that he hadn't been tortured. He confirm that he's been treated the same as everyone else, which is a rather perverse cross-examination, considering that we know that most other prisoners there have been abused or at least subjected to really inhumane conditions. So Sharapov says casually, yes, I'm treated the same as everyone else, and then he refers to Guantanamo as a sanatorium. And that's where the cable report ends. We don't know what happened to these individuals. The International Committee of the Red Cross doesn't have access to Tajik prisons because the Tajik government doesn't let them have access. But we know that this kind of monitoring doesn't work. And we know that the US sent these men back based on diplomatic assurances after having heard reports from Human Rights Watch and from others that other people sent back from Guantanamo were abused. And still, we haven't actually, the US government has taken a lot of important steps in the last few years, but we still haven't foreclosed the option of sending back another Tajik detainee, Maher Arar, from Guantanamo to Tajikistan. This plainly isn't doing our best, and this is really doing what we can get away with. Because of the lack of information, the opacity of the US government continuing, we can do a lot of things, we being the US government, and not really have to explain, and it will be years, hopefully not involving me, but Peter and another set of clinic students. It will be up to them to uncover, years from now, more tales about what's happened to the people who are being sent back from Guantanamo, and to help us understand how to deal with this evolving issue.
Thank you. Thank you to all of the panelists for these presentations. Let me first turn to the panelists to see if you'd like to raise any questions to others on the panel. And then from the audience. I think we've gotten a sort of a beautiful description of both the evolution of the engagements and of the issues of practitioners who have tried to take on the issues. I mean, one of the themes, and you've heard it addressed, but perhaps not as directly as we've all faced it, is really whether to take an abolitionist position and say no under no circumstances, or to work, as Ashley said, pragmatically to try to come up with recommendations. And the dilemma, which I think we've heard here very clearly, is that at the very least we know that from the early cases that there was a lack of seriousness to begin with in the commitment to any effort to ensure that there wouldn't be torture. Maybe that's changed. Some governments have subjected that process to active public scrutiny. One government clearly hasn't. That's the United States. And for every bit of information that continues to be leaked, we see something deeply embarrassing. And this was one of the big struggles we had with the report, was how long to wait, how many more WikiLeaks cables to wait for before we publish the report. We saw the report from Tajikistan, we saw from Tunisia, we've seen the comments from Egypt, comments around China. There always seems to be a kind of naivete about the American diplomats in the process, that they thought they were going to have that access, that they did believe in it, but then they didn't get it, something didn't happen. I guess maybe as one of the people who, in working on this report and working on this process, that has always pushed for the possibility that these could work, I would ask you, Ashley, what do you say about the fact that we still have nothing to show that they can? We have nothing to show in concrete detail what realistically has been put in place or can be put in place to ensure, under the circumstances where we send people back, that they won't be tortured. So even before we get to the place where Julia has led us, where she says, I don't care, actually, so protect this person, that actually is still destructive to our international efforts for torture. So let's leave that aside for a second and just say, can we do it? We know the awful cases.
So if I understand what you're asking, are there cases in which assurances have worked? Where the U.S. government believes that people have been sent back and the states have the receiving states.
Well, we know a lot of cases where people haven't been tortured. I mean, the one we filed a FOIA request with the ACLU, and it's documented here, and the U.S. government eventually disclosed one case of a return of a person named Barapin to India, and we later followed up, and he hadn't been tortured. So he wasn't tortured. But there's no reason to believe that the assurances that any process was put into place there. So we can't track any of the mechanisms that were put into place. The other thing we learned from the Barapin disclosures were that with previous people who'd been returned to India, there'd been no follow-up monitoring. So no one knew what had happened to the earlier cases. So we don't have any, we might have cases where people weren't tortured, but do we have cases, do we have information that says a monitoring system put into place protected these people? Something that can actually focus, that can get us to the point even of saying that in these individual cases we have more reason to believe that they were protected and that there's mechanisms that would ensure it for the future? Or can that information be disclosed?
Right, well, clearly the information hasn't been disclosed to date. And I guess I'm not really in a position to say much more about sort of past monitoring. I guess I would say that the executive order process was a useful one, at least from my perspective anyway, in thinking about greater harmonization of practice. I would also say, though, that every case really is different, and there are some cases in which the U.S. government might seek assurances from a country that doesn't have a particularly bad human rights record. And so it might not make sense to have an identical monitoring system negotiated with that country. It might even be a European country where there are sort of particular concerns that a detainee has raised that seem credible enough to the government that they want to just kind of use a belt and suspenders approach. So if you had a sort of one-size-fits-all monitoring, that wouldn't necessarily be great. And even the UK, which is now being very public about its monitoring, doesn't have kind of precisely the same monitoring across the board. One of the things that I had proffered and hoped would be a potentially useful solution would be if there are monitoring groups being kind of put in place as a result of the UK efforts, then you might actually find entities that are more equipped kind of in a systemic way to recognize torture, to know how to deal with the psychology of the detainees and so on, rather than people who are tasked to monitor who are not experts in that. So if there were a sort of repeat player type of monitoring possible, it seems to me that there are downsides to that if they fall out of favor with the country that they're operating in, but there are also upsides if you have a number of states transferring people to a country and one monitoring group that the states are relying on. It may give greater diplomatic leverage from the transferring state over the transferee state. And the other thing that I had suggested, I don't know how realistic this is, I think Felice may know much better, but the optional protocol on torture is a mechanism by which states, I believe, can adhere to and more or less open up their facilities to visits by a UN body. And while the US is not a party to the OPT for constitutional concern reasons, I had suggested that the Europeans, which I believe are parties to it, urge their counterparts that are sort of less maybe human rights focused to start to adhere to that protocol, which could be another mechanism for monitoring, maybe not of particular people, but that may be better, right? That may overcome some of the concerns that Julia, for example, raised at the end of even if you can secure appropriate treatment of the person you're sending back, or what kind of message are you sending about how is it appropriate that other people in that facility may not be treated as well as the sort of gold standard you've tried to create?
Felice? Yeah, and afterwards, Julia?
Yeah, and Felice, you should correct me on OPT because you are much more of an expert than I am.
Well, I was fascinated to hear that the reason the U.S. is not a member is constitutional reasons. I have never heard that before.
I'd understood there was a Fourth and Fifth Amendment. Oh, it's maybe it's a federalism issue.
Well, the federalism hasn't kept us from signing other treaties. And I don't see that it should. I don't think it should here, and it's actually something I had hoped that this administration might take up. We know some things work in preventing torture. We know that having access in those first 48 hours or such to a lawyer and a doctor and family members is the best deterrent. We know that monitoring by independent groups that can visit at will, at any hour, at any place that they want to, can be a deterrent and can be very helpful, and they have found extraordinary things. Now, whether the OPT, the SPT, the Subcommittee on the Prevention of Torture created under the optional protocol, is the vehicle that can do this, is another question. That is a committee now of 10 people, going to be 25 sometime this year, which does do these sort of site visits, like the European Committee. But what the optional protocol creates, which is better than that committee, is national bodies that are supposed to do the same kind of random inspection. And if they are really independent and well-funded and operational, they can do a great deal that can be helpful. We've had arguments about the issue of modern technology and whether with real-time video monitoring and other kinds of things one can do the kind of monitoring for that'll work and that'll protect people. And we all know about what you do off screen and how you get people out of sight. But still, this has been technology allows us that. bigger issue, it seems to me, is what do you do with, you don't want to be creating zones of impunity. And if you don't return people who are sought for bona fide offenses, then you need a place to try and punish them. And it seems to me that there is actually a mechanism, but nobody really wants it. You could create a chamber of the ICC. You could create a separate you could create a separate a chamber for terrorism and other suspects who are unable to be returned to the country of origin, which would be a way of avoiding impunity and, if you're having it in Holland or places like that, avoiding torture for such persons as well. So you could deal with the issue in a real way, it seems to me, by a combination of such pragmatism. Now, the other thing is this business about the State Department. I was surprised that the report says that in the future, if I read it correctly, all diplomatic assurances should be negotiated by State Department officials. And I guess that you were concerned about people in intelligence agencies or on the ground in other countries making the deals. But I would argue that it should be a Justice Department official. If somebody's going to make an agreement about the treatment of a detainee, it should be somebody who deals with detainees and detainee conditions and justice and redress and things of that sort, and not a State Department official whose goal is to remain friends and maintain access with the country that he or she is dealing with. Because, I mean, that's a major problem. Secondly, the State Department officials, it's a diplomatic, we have our own diplomatic people who go in and supposedly do the monitoring. That's the way these things are set up, although the British system is a little better in coming up with independent monitors. And it seems to me that our State Department officials and the Swedish diplomats and the Norwegian diplomats and everybody else diplomats who've been involved in these diplomatic assurances situations have no expertise in this regard, and actually are discouraged from going in because each time they go in, they give up a chit on some other diplomatic priority or nicety that's there. So I think there are ways to deal with the impunity problem. I think there are ways to improve protection against torture and ill treatment in every country. The countries give us their word that they're protecting people, and they give that, when I say us, I mean the Committee Against Torture or the UN, but we have no capacity to hold them to that other than public exposure. I think there are mechanisms.
Can I just, do you want to?
If I could just respond to the sort of why State Department. The State Department is basically the negotiator on behalf of the U.S. government for virtually all treaties and often many MOUs, but it doesn't operate sort of standing alone without any consultations with other agencies. So, for example, when I did extradition work, the Justice Department is a key player in requesting people to be extradited from other countries and from facilitating the process of extraditing people from here. So we sit at the table with the Justice Department when we're negotiating extradition treaties. And in law of war treaties, the State Department isn't fighting the armed conflicts, but it has the defense officials who do sitting right next to it in negotiating those treaties. So I think it's useful to have one entity in the U.S. government that can kind of harmonize the process and bring a particular expertise, including the Democracy Rights and Labor Bureau, entities within state that do have kind of expertise and focus on mistreatment of people abroad as kind of the core. And also, I had recommended that there be one agency as a body to sort of collect the practice that has come up in different U.S. government experiences so that you can have a database and say, okay, well, what happened when we sent somebody to Tajikistan before? I think it's very important to have all of that information in one place. But that's why I think it does make sense to have state negotiating, even if it has justice over one shoulder and DHS or whoever over the other.
I think it might be useful, given that whole conversation, to really talk about what the standard is. Right? The standard is not send someone back, and if they're not tortured, there's no violation. And if they are tortured, there is a torture violation. That is not the standard. The standard is you're not permitted to send someone back if they are at risk of torture. And it is this, what Felice says is true. It's a probability game. You assess each case individually. So the idea that we say, could there be post-return monitoring? Who could do it? Just the notion that you have to implement that system with respect to that one person indicates risk. It acknowledges risk on return, right? So it's almost inherent to the need for the assurances themselves that you're acknowledging that that person is at risk. Now, we have met with the U.S. government, and they've said, well, we don't have a but-for policy. And for those of you who don't know what that is, in the U.K., the standard is, but for the assurances, we would not send this person back. We acknowledge this person is at risk. We have assessed the person's individual profile. We understand the markers that put that person at risk. And but for the assurances and the post-monitoring return mechanism, we wouldn't do it. When you have that kind of a situation, I think you have to remember that the probability game here means that it's the assurances that are supposed to keep that person safe. It's the monitoring that is supposed to keep that person safe. And we don't really have any indication, as Peter said, that it is the assurances that have kept, not even in one case, to be really honest with you, not even in one case do we have any evidence that it was the assurances that kept a person safe. We have cases where people have been sent back, and there's a very prominent cat case called Pellet, the Azerbaijan, where Ms. Pellet was in fact sent back based on diplomatic assurances. She was not physically assaulted when she went back. She was not harmed physically. We're still, I think, very weak on the notion of psychological torture. But let's just bracket that for a minute. I think we do need, it's an under-researched issue in international human rights law. But the committee still found an Article 3 violation. And they found an Article 3 violation because the risk assessment was not done correctly, because the way that they handled her case violated her rights and sent her back to a risk of torture. The committee did not require a torture violation upon return. If a person is sent back and tortured, there are two violations. There is a violation of the non-refoulement obligation, not to put a person at risk, and there's a violation on the part of the receiving country that they tortured a person. And so I think sometimes the chronology is funny, you know? We don't know actually which way the arrows go. But the only way to keep a person safe from torture, if they are at risk of it in a receiving country, is not to send them back there. That is the only way to observe the absolute obligation, not to put that person at risk of torture.
Can I respond to that?
Yeah, absolutely, but let me also see if
let's
there's
have
going to be, if we have questions or people thinking of questions, they're coming up here. Okay, good to know that. All right, so.
No.
No, go ahead if you want. Okay, let's go to some questions. Yes, sir. If you don't mind introducing yourself and speaking really loudly because we don't have microphones.
My name is Adam Jacobson. Ms. Gare, you mentioned reparative steps. I'd like to ask the
Mentioned what?
Reparative steps?
Yeah.
Yeah. If you could talk about if there have been any cases of compensation for victims of diplomatic assurances who have been tortured, either through lawsuits or just on the part of world governments.
Well, the easiest case for me to bring up in the context of what we've talked about now is the Agiza case. We have, and if you look at last year's annual report of CAT, under follow-up to Article 22 cases, you'll see about 5 pages in which all the follow-up on the Agiza case is summarized. But if you look earlier, you'll see even more information, among which the government of Sweden says, we have paid him compensation. The Arar case, another case where the government of Canada has provided $10 million in Canadian dollars in compensation as a reparative measure. In the case of Agiza, the committee has said it's not enough. The lawyers for Agiza are seeking a residence permit for him, and in Sweden. And Sweden has refused that, saying, I don't know if there's been a change recently.
They refused it.
They've still refused it. And they've refused it, saying he is a security risk to the country, and they're not giving him a residence visa. And his lawyer has said, but even as a psychological reparative measure, to know that he has that would help him now, even if he's in jail and is going to stay there for a while. I don't know which jail he's in. He might not be there
He's in
anymore.
Torah.
So he's still in jail
That's
in
why he left. He
Egypt.
was in
Yeah,
Torah.
but
So
yes,
unless
compensation.
That jail has been opened in the last
Compensation is one of the
hours.
reparative measures, and we have, when we find a country in violation, we tell them that they have to repair the violation, and that they have to follow up with the right to redress, and the convention calls for fuller rehabilitation as possible, and compensation and other reparative measures. We had one case, I think it was the Dadar case, I'm not sure. This guy went to Norway. He was refused refugee status, and he was returned to a country in Asia. And we found a violation in connection with how he was sent back, and the risk issue as well. Government of Norway went and they got him. They actually went back to that country, got him, brought him back to Norway. Well, the end of the case is really even more bizarre, because in the end, he turned out to have lied, and they said there was a whole other set of things. But they followed procedurally the case, and one of the reparative steps they took was to physically go and get him out of the country he was in.
In Agiza's case, they rescinded the expulsion orders. The government of Sweden paid reparations. They granted Hananatia,
Yeah.
who originally came to the CAT, full asylum.
The wife.
So she's got full refugee status in Sweden. They did two separate internal investigations that don't actually meet international standards for investigations for torture, but in any event, and they rescinded the original expulsion orders, right, which is acknowledgement that, symbolic, however symbolic it is, that sending them out of the country in the first place was a violation, and this is how they symbolically corrected the violation, by taking back the orders.
Another question? Yes?
I have a question for the whole panel, especially Julie.
Could you introduce yourself and speak really loudly?
Sure. My name is Richard Wright. I'm a first-year law student. My question is about alternatives. The police proposed an interesting alternative to be a subset of the ICC, but I'm curious, in the case of, let's say, a Tachi who's detained in Guantanamo, who may be at risk of torture if we return them, what would your alternative be? Would it be indefinite detainment at Guantanamo? Release them? What are the better options that we have?
Well, it's been very tough. I mean, the Guantanamo issue is tough, and there's nobody in right mind who doesn't acknowledge that. Dan Fried is the ambassador at large, who is basically traveling the world looking for third countries to resettle Guantanamo detainees, and he's had a certain measure of success in Europe in the last 2 years. I don't know, maybe 10 odd countries have taken them. Guantanamo detainees who cannot be returned to their home countries because they would be at risk of human rights violations there. So that's one alternative. The other alternative, which we don't see any light right now, is for them to be admitted, to the U.S. I mean, we tried that very vigorously with respect to the Uyghurs, who had been largely acknowledged to have been at the wrong place at the wrong time, right? And who couldn't be sent back to China because they would be very much at risk of ill treatment if they were sent back there. But there's real opposition.
There's a bar.
Well, thanks for, you can't do it. You can't, there is no room to send people to the mainland. So I think the U.S. government tossing the government a bone has really tried very diligently over the last few years to resettle Guantanamo detainees. And I think that is the only alternative to date that we know of, unless they are willing to try people in civilian courts, U.S. federal courts, and find them guilty in a fair trial, Of course, that is the optimum thing if they really feel like some of the people remaining at Guantanamo, that they have claims against them. But there is a significant population there who will never face a military commission or a federal court trial, who do need homes. And so the only thing, to my knowledge, that the U.S. is doing as an alternative is the whole resettlement program. And like I said, there's been a certain measure of success with respect to that.
Can I also address that, Peter? So the other context in which assurances are coming up, in which I think it is difficult to find another set of options, are the detainees in Afghanistan and deportations and extraditions. And I would just start with deportations and extraditions. So other countries, including Canada, have also dealt with cases where there was a deportation based on assurances, and in cases where they haven't, where the courts have forestalled that deportation, those people have been put under supervised release. Orders of supervised release are incredibly onerous. In the U.S., there's cases where people have to wear these ankle bracelets that they have to plug into the wall at night, and I don't even know how that works for you to be sleeping, and they're not allowed access to computers. Their families really suffer. So supervised release is not a civil liberties positive alternative, but it is an alternative in the immigration context. And more generally in the immigration context, we're not just talking about terrorism suspects. Under the regulations that were mentioned earlier, anybody who had won withholding of removal under the Convention Against Torture, not withholding of removal, but deferral of removal under the Convention Against Torture, could still be sent back on the basis of diplomatic assurances. And that would include also people who were barred from asylum for other reasons unrelated to terrorism. One of the recommendations we make in the report is that there's not a security-related need to keep those people, to get those people out of the country. The risk is just too great, so that we shouldn't be removing those people in the first place. In the context of Afghanistan, I think Ashley raises a really important point, which is that at some point, one would think that the Afghan government is going to stop tolerating, or at least the scale of detention that is going on right now with about 1,000 or more than 1,000 individuals at the Parwan facility in Afghanistan. So what will the U.S. do with those people if we handed them over? Compensation, forget it. There's thousands of people that are citizens of another country, either Afghanistan or citizens of some other country, and they don't have access to our judicial system. So what continuing responsibility can the U.S. have for those individuals? There are alternatives, though, to transferring them to the National Directorate of Security, which is the Afghan intelligence agency that generally takes the individuals from ISAF, International Security Assistance Forces, U.S. forces. And that would be the ANDF, the Afghan National Defense Facility. There's facilities that we've already created, and there's personnel that we've already trained in Afghanistan with more rights-respecting policies. We could also open a facility in coordination with our allies, with Canada, with the Dutch, with the UK, other countries that are detaining individuals, and that facility could be under Afghan authority, but with substantial training and investment from all of these different groups. And it also could be monitored in a more sufficient way, because we could actually embed our personnel there for a time. So it would be under Afghan sovereignty, but with ISAF assistance. And because it would be a dedicated facility, we would have greater access and more round-the-clock intrusive monitoring. Not that that is ever really sufficient with an organization like the NDS, the Afghan NDS, which is known for concealing abuse. But it is a starting point, so there are things that we can be doing.
Did you want to respond to my Article 3, the standard issue?
I'll respond to you. Sorry.
Okay.
So we should wrap up. We've already gone a little bit over. I don't know, Ashley, did you still want to? No.
No. I think that's a good place to end.
Okay, I think we will end there. I think we've covered a great deal of ground and raised a lot of issues. Thank you very much, and thanks to the panelists. This has really been a great opportunity for us, and you've really more than realized our hopes. Thank you.